Welcome to the Center for Free Expression's first virtual panel in 2023. I'm Jim Turk, the director of the Center for Free Expression. We're delighted to have you with us today. Today's panel is going to be dealing with the issue of whistleblowing. Before we begin the panel and introduce the panelists, I'd like to acknowledge the land in which I'm speaking to you today is the traditional territory of many nations: the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Métis, and Inuit peoples. I'd also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed by multiple Mississauga and Chippewa bands. I'd also like to thank the co-sponsors for today's panel, and they are the Edmonton Public Library, the Milton Public Library, PEN Canada, the Toronto Public Library, the Vancouver Public Library, and the Whistleblowing International Network. We're appreciative for your support. People who speak up about wrongdoing are going to be the focus of today's discussion. They speak up about wrongdoing that harms the public, and they're often, if not usually, treated very badly for having spoken up. Most jurisdictions have whistleblower protection legislation to protect them, as Canada does, and as do all the provinces in Canada. The problem is that this legislation is not very good. Canada's federal whistleblower protection law, in fact, I would say, is terrible. In the more than 15 years it's been in operation, since it was first introduced in 2006, and at a cost of over $100 million, our federal whistleblower law has not protected a single whistleblower out of more than 500 reporting reprisals having been taken against them. We're going to explore today what has gone wrong and what can be done. We have a truly impressive panel of people who have been engaged with these issues for years, and I'd like to introduce them to you now. First panelist is Ian Bron. Ian is a lecturer in public administration at Carleton University. He's a senior fellow of the Center for Free Expression, and he has firsthand experience as a whistleblower who brought to public attention serious problems in Transport Canada's oversight of marine transportation security, and paid a heavy price for having done so. Welcome, Ian.
Nice to be here.
Our second panelist is David Hutton. David is one of Canada's leading experts on whistleblowing and whistleblower protection. He headed a major whistleblowing organization for a number of years as executive director. He is a trustee and one of the founders of the Whistleblowing International Network and a senior fellow at the Center for Free Expression. Welcome, David.
Nice to be here.
Our third panelist is Anna Myers. Anna is executive director of the Whistleblowing International Network, and she's based in Glasgow, Scotland. She's a United Kingdom lawyer, also called to the bar in Canada. She's the former deputy director of Public Concern at Work, now called Protect, which is the leading whistleblower protection and advocacy organization in the United Kingdom. And then she worked at the Government Accountability Project in Washington, D.C., the major whistleblower assistance and advocacy organization in the United States. We're happy to have you with us today, Anna.
Thank you very much, Jim.
And our moderator for today's panel is Karen Pugliese. Sorry, I can't even talk. Karen is the editor-in-chief of Canada's National Observer. She's a former managing editor of investigations and current affairs for CBC. And prior to that, she was executive director, news and current affairs for the Aboriginal People's Television Network. Welcome, Karen.
Thank you.
The format for today's panel is that the panelists are going to have a discussion, a conversation amongst themselves about the variety of issues related to why Canada's whistleblower protection legislation is so bad, what it should be, and what can be done. And then they're going to turn to the audience to answer any questions you may have. If you would look at the bottom of your screens, you'll see a Q&A button. Anytime as you're listening to the conversation amongst the panelists and a question comes to mind that you would like to ask them for clarification or an issue you'd like them to take up that they haven't taken up, just click on the Q&A button and write out your question as you think of it. You don't have to wait till Karen turns to the audience later in the conversation. So just put your questions down as they come to mind. Ange Holmes, who's the coordinator of the Center, monitoring the questions. And when Karen and the panel turn to the audience for questions, Karen will ask Ange to share the first question that's come up, and we'll go through them at that time. But we really want your input and your questions, so please do take the time to ask questions as they come to mind as you're listening to our panel. That's it. Thank you very much, and we're looking forward to your conversation. Over to you.
Thank you so much, Jim. And first panel of 2023. So everybody, Happy New Year, first of all. So happy to be here with all of you. Jim just in that introduction said so much, and there's so many things I want to get to. I think though, Anna, I'm just going to start with you, and I'm going to ask, why should I care, and everyone listening care, about whistleblower legislation right now?
Thanks, Karen. Yeah, well, other than the fact that it is one of the most important ways that we learn about corruption, about negligence, and about wrongdoing, I think that that's probably the main reason people should care, because when people speak up, and it tends to be people within the workplace who come across wrongdoing, without, most people are doing their jobs and they raise it in the course of doing their jobs. And it's only when the reaction and they start to realize either that the issue is not being addressed or the attention is starting to focus on them in a way that they're not used to and they don't understand, that they find themselves in a whistleblowing dilemma about whether they should actually take it further than the normal course of events. And I think we've all lived through in the last few years a pandemic. I think many of us didn't even occur to us in those first weeks that we shouldn't be hearing from doctors and nurses and what was going on. Maybe those hospitals and their management didn't really like it. And certainly in the care sector, when we started to hear what was going on, we started to learn how they were starting to be gagged. But as members of the public, it blew away any of this kind of artifice that this shouldn't be information that we should know about. And it's the same when it's corruption within government procurement, with negligent projects where our taxpayers, our money is going, but most importantly, when there's a risk of harm to us. And so I think right now, and I'll end on one other point, is that I've worked in the field for 20 years. So we used to nicely talk about it. When I talked about whistleblowing, I'd slowly explain what it was. I sometimes didn't even want to bring it up because it was quite long, the conversation. Now people kind of have an idea. It doesn't take too long. But in the beginning, we talked about it as a backup mechanism. This was the backup when our accountability mechanisms weren't working, when our management wasn't picking it up, when the senior people in an organization didn't want to deal with it, when our government started to shut it down, either from embarrassment or because they really thought something was going on. But now we're seeing it as almost like a front line of defense. And we can see that in countries in Europe and in North America who have relied on their democratic institutions to pick these things up. And we're not seeing the same kind of trust that will happen, but we're also seeing that a lot of these institutions haven't been funded very well. They don't work very well. And so people are ending up having to speak up if they want things addressed. So I think the real challenge in the discussion that I hope will come out today is, how do we support those people? Because if we're going to rely on them more, then why should it be up to individuals? And those individuals are more vulnerable than the institutions that ought to be addressing the issues and protecting those that let them know.
Thank you. Thank you for those examples. And that's really interesting way to think of it. It's gone from backup to sort of frontline, sort of the thing that you really need. And that's just such a great introduction to, I think, Ian, because Ian, as Jim mentioned, you were a whistleblower. This is in 2006. It's before there was whistleblower legislation. So we'll talk a little bit about after, but I was wondering if you could just refresh everybody's memories on why you became a whistleblower and then how you were treated. What happened to you?
Yeah, so I kind of fell into a gray zone. There was whistleblower legislation in the pipeline. It was coming down, but it hadn't been brought into force yet. So I was at Transport Canada, and we were developing some regulations to secure the marine transportation sector in short order after 9/11. The process was imperfect, and there were a number of gaps in the process, but also the implementation was sloppy and sometimes negligent. For example, there was an inspector who was ordered to stand down when he attempted to enforce a particular regulation. So I tried to bring issues up, like many whistleblowers. I tried to bring them up internally. I brought them up the chain to our integrity officer, internal departmental integrity officer, and that was absolutely no help. Basically, we were told, that it's in hand, and don't worry your little head over this, and carry on with your life. That wasn't really good enough for me and some of my peers. So I put together a report basically detailing all the concerns we had about the regulations and about some problems that were inside the organization itself. And I disseminated this to a Senate committee, to the head of the department, and to the Auditor General, because at that time there was absolutely nobody. The previous integrity officer had been stood down. That office had been stood down. The new commissioner wasn't yet in place. So I just didn't see any other place to go. And I certainly didn't want the problem just to keep going, because it was not in anybody's interest. The reaction was immediately hostile. I heard later that they convened a week-long meeting to decide how to respond to my disclosure inside the department, all the top people. And they came up with two primary strategies. One was to attempt to yank my security clearance. This is a great way to get rid of people in governments, because once you don't have it, you don't have a job anymore. It didn't work.
It didn't work
because
right.
Exactly right. The official who did the investigating had enough integrity to protect me from that. So they went to the second avenue, which was to say that I had harassed my superiors in making the disclosure. So they basically said, without even investigating the veracity of any of my claims, they just said, well, you've harassed your superiors, and there's going to be an investigation. I was never allowed to see the full list of allegations against me. They steadfastly refused to give us that. And we tried to shoot back by filing grievances. A couple of my peers. The first level of the grievance was heard by one of the people we had named in my disclosure. So it was this bizarre, perverse situation where I'm being judged by one of the accused. And my union was absolutely no help. At the end of that meeting, after making a token protest, he stood up and started talking with this particular director general about a golf tournament they were both going to be attending. So it became pretty clear to me that this was not going to go anywhere. I was also getting threats of legal action at home by some of the people I named in my report. It was incredibly stressful. We tried suing back, and that eventually died because of changes to the Labor Relations Act in the federal government, and I became a precedent. The whole thing from start to finish took about 7 years. By 2012-13, I realized I just had to move on with my life. My marriage had crumbled, suffering stress on stress leave for years, just because the work environment. And this is even after I had left the organization. They basically banned me from the building that I had worked in. But when I went to the new one, they also said, make sure your employee never comes into our building. It was a level of pettiness and spite that truly beggared the imagination. I don't think it's really changed since then, though, because even though the law came into effect about 6 months later, the Integrity Commissioner had the option of retroactively looking at my case, even though the law wasn't there. And my lawyer was told, after communicating with the Commissioner's office, that they probably wouldn't, which we now know after the performance of the first Commissioner was definitely wouldn't, because she never looked at any cases seriously. The stories I've heard since then are basically parallel to mine. I think I made one of the classic errors, which was to assume that if I took the issue to the right level, that somebody would act on it. And that's the first misconception many whistleblowers have. And the second one is that it can't get worse than this. And yes, it can. It can always get worse. They can pursue you. The idea is not just to discredit you; it's to essentially destroy your credibility entirely and dispirit you to the point that you don't take any action. And I've seen that played out with other whistleblowers since. Departments still have a real pattern of neglecting issues that are initially raised within them, and then maybe very informal investigations that don't really get to the heart of the matter. And then when the whistleblower gets persistent, they treat that as the offense, as the problem, and they really come down on them, especially if they go externally. If anything saves whistleblowers these days, it's when the department gets too bold and makes a mistake. Mm. Otherwise, I'd have to say not a whole lot has changed since that law came into place.
Yeah, and so I had a canned question that I was going to go to, Dave, but I've been kind of looking at your face, and it just looks like you just want to jump in and say something. So maybe I'll jump in and give some thoughts, and then I'll ask my question after. How's that?
Well, I'm interested to know what the question is, but no, I mean, listening to Ian, I jumped into this arena around the time that law was being introduced. And I was part of a group that presented to Parliament how useless this was going to be. And in fact, the Senate...
So, sorry, to interrupt you for a second. You knew it was going to be useless. You knew the law that they were putting...
Yeah, absolutely. Yeah, I mean, and so the Senate heard our testimony, and they passed 16 or so amendments to the law, which would have improved it significantly. All of those were struck down by the government. So, so listening to Ian, what's going through my head is this is such a typical story. You hear that, in my work for a charity, I had dealings with about more than 400 whistleblowers and heard their stories. And while the wrongdoing they were describing varied enormously, different parts of the country, different organizations, different levels of severity, the story of the reprisals was almost like a carbon copy each time. And there was nothing that I could do for them, because the lack of law, there's really no place I could send them, and little that I could do for them other than to help them to understand what they were up against so they could make better informed decisions, because most whistleblowers are quite naive about what they're up against. I'm not criticizing them. As good citizens, we tend to believe our government's on our side and the right things will happen. And it's absolutely shocking and incredible to them when the whole system turns against them and they're just persecuted like vermin.
It's so it sounds just so much like a movie scene, right? That some forward and you think that you're doing the right thing, and what you're saying is going to help. It's going to improve the system, maybe even save lives, and the whole system turns on you. Like it sounds. I mean, I know it happened, but it sounds so incredible. And the other thing that was really incredible to me was when Jim said at the beginning, and this was the question I wanted to ask you. I partly answered it, but he said that since 2006, this legislation came through and it has not protected a single whistleblower. Is that true?
Yeah. No, your reaction is typical. I've said Jim's exact words pretty much to lots of people. And the typical reaction is, oh, that can't be right. This guy is exaggerating. So I want to take a minute just to explain how that statement is absolutely correct. The law called into existence two new bodies. One was an integrity commissioner, whose main job is to investigate wrongdoing. And here's all the powers of the Inquiries Act, actually. The second body is a tribunal, whose job is to adjudicate claims of reprisal. So the whistleblower may go to the commissioner with a disclosure of wrongdoing. If they suffer reprisals, they go back and say, look, I'm suffering reprisals, please do something about this. And the only body in Canada that can provide any remedy to a whistleblower, a government whistleblower who is suffering reprisals, is that tribunal. That's the only place you can go. But there are some obstacles. The first one is that the Integrity Commissioner almost never sends anyone to the tribunal. He's got the role of a gatekeeper, and out of 500 people who've complained about reprisals, and we think there are a lot more than that have, but out of the 500 who made formal complaints, I think the number today is about 8 who've been allowed to access to the tribunal. So almost no one gets to go there. The tribunal itself is set up under the legislation so that the whistleblowers really have no chance at all. There's a little bit of a technical issue that I'll explain. We've learned through experience decades ago that it's almost impossible for an employee rather, to show that actions against them are reprisals. The employer has all the cards and all the information, and they simply claim this is a bad employee. So we know that doesn't work. And the remedy, the way of getting around that is what's called a reverse onus. So if there seems to be some kind of connection between blowing the whistle and the reprisal, the actions taken against a whistleblower, then the burden of proof shifts to the employer to show that those actions were not reprisals. Now, that gives them a chance. It's not a slam dunk, because even with that assistance under the law, only about 20% of people are successful. But it's better than zero, which is what you've got the other way. So we do not have this reverse onus provision in the law. And therefore, what's happened is that everyone who's gone to that tribunal, who's been allowed to go to the tribunal, has either bailed out or failed. So most of them have bailed out pretty quickly, and I've spoken to nearly all of them. And they bail out because they realize they're into a cruel, expensive, never-ending process where the other side has a team of lawyers, literally paid for by the government. They may have nothing. They've got this reverse onus issue, and they just realize, I got to get out of here, and they'll take whatever crumbs they'll be offered as a settlement, and just to get the thing over with. Very few have persisted. I think at this point in time, only 2 people have completed the process, and the tribunal found against them in both cases. So that's the sequence of events. The 500, the 8 or so allowed to go to tribunal, and then 0 success. So it's absolutely accurate. No whistleblower has ever been protected in Canada by the system, and it's kind of ridiculous.
Wow. And I'm thinking about like exactly that issue that you brought up, how unfair that is, that I mean, they can just, it sounds like they can just kind of almost character assassinate you, right? Like they can say you were a terrible employee. These reprisals weren't reprisals. You brought them on yourselves. That's the kind of thing you're talking about.
Oh yeah, and you know, one of the battles in our field is that the word whistleblower has so much baggage attached to it. And you know, as Anna was saying, that's changing. People are beginning to understand better. But the reason for that baggage is that every single time you see a whistleblower case discussed in the media, there's an all-out assault on the whistleblower, on their credibility. Nuts and sluts is the phrase that we use. They're described as being crazy, immoral, whatever negative thing you can say about them, that's there in the media. And they're just, you know, vicious, nasty troublemakers, and no one should pay any attention to them.
That's really interesting. It's really interesting, like as a member of the media, it's really interesting to think how I can be manipulated by that.
Yeah.
Interesting. So I'm going to ask, yeah, please jump in.
Sorry, I was going to interject, and it hasn't really been helped either by legal interpretations of the Act. In general, the courts tend to treat whistleblowing as an ordinary employment dispute, not as a David versus Goliath situation in which it really is. The whistleblower no longer has access to any of the evidence that they had witnessed, and the organization can essentially draw on all its resources and sometimes fabricate evidence. I've heard of evidence being fabricated, documents being backdated, that kind of thing. The justices don't tend to understand this. The most recent case that went through was heard at the Federal Court of Appeal. It involved a government lawyer named Yassine Agnew, and the court argued that there was no need for any reverse burden of evidence that David was talking about, because there was no free speech component to this, which is frankly unbelievable, since it's actually written into the preamble of the act that the act is intended to balance free speech with the duty of loyalty to the employer. So that gives you an idea of the kind of hurdles that whistleblowers have to face, not just with the limitations of the law, but the interpretation at the judicial level.
Yeah, well, about that you said, sorry, I just want to ask this, so I'll go straight to you, Anna, but you pointed out that they're looking at it as an employee like dispute. Well, that's not really fair, is it? Because it's not just about, hey, I didn't get the bonus that I was supposed to be paid. Like, you're looking at moral, ethical issues, people being in danger, maybe, potentially, wrongdoing. So it's not an employee dispute. I just wanted to pull that out from what you said, because I found it interesting. Go ahead, Anna.
Karen, that's exactly the point I was going to bring up. And when I started 20 years ago, they had just come out with the Public Interest Disclosure Act in the UK, which differently from the Canadian situation covers every worker, because within the UK you have a system of employee protection that covers whether you are. And what's interesting, the Public Interest Disclosure Act would cover, say, civilians working in defense industry, civilian workers, not the armed forces, not the officials, but it did cover the civilians. So you had these some funny training sessions we did where they were like, half of us can be protected and half of us can't. But even there, where you had an employment tribunal, I think the person that was really sort of instrumental in getting that law in the books, Guy Dane, who I worked with for a number of years and was the original director of Public Concern at Work, and they started on this issue in 1993, said that in a way, one of his regrets was not having a specialized tribunal. And the experience internationally, because I run the Whistleblowing International Network, so we have members across the world, the only country that has actually done training of judges is in Serbia. And interestingly, when I looked at the stats on the Canadian PSIC and how it took people from the beginning of making a complaint to the Public Sector Integrity Commissioner to the point at which those 8 cases took 6.5 years, close to 7 years. Now that you think of in countries where judiciary runs slow, right? And that was always a problem in Serbia. The judicial system isn't that great. And if they're really difficult cases, I think judges don't want to deal with them and push them into the long grass. They trained with the Judicial Academy, and having a law that had been put together with a whole group of stakeholders, including whistleblowers who'd been in the judiciary and in the police, where people really understand those cases, right? They understand why judges need to be able to blow the whistle on corruption in judges. And we understand why doctors or nurses need to blow the whistle on incompetent doctors, for instance. We get that, right? Now, whenever I do examples, I tell bankers about those stories. And then I tell the doctors who had all their money in the bank, do you want the money to walk out the back door of the bank? Don't you want your kids to go to, have a university education? So you try and sort of put it where people will understand what this is about. And the training allowed the judges to suddenly go, oh, I get it now. And they had interim relief, which is something that you could ask for, I want interim relief that this situation against me in the workplace, and this is a public interest issue that I've raised, and now I'm in trouble. I can ask for a court to step in and tell the employer to stop all action. And that interim relief applications were going through when the law first came through in Serbia after the judges were trained. They were like agreeing it within 2 weeks through the Christmas holidays, and it's Orthodox Christmas. It is not, you don't mess with Christmas in Serbia. The idea that in Serbia they were doing it like that, I think that it got started on that slightly wrong foot in Canada. It was seen as an administrative measure. It was seen as an idea of sort of us knowing what is going on in our government departments and maybe remedying something. But this idea that you create a cardboard shield for people who are going to have the weight of the power come down, sort of the house of cards fall on them. You don't need a cardboard shield, you need a metal shield. And you need the judicial system to understand the public interest is the main party in this. It's not an employee-employer dispute. It is, and if they don't see it that way, then we're stuck. There's a kind of attitude behind the law that just doesn't exist in Canada. There is power within those laws that nobody has been using. And the public sector commissioner could be sending all the cases to the tribunal.
David,
They have that right.
Yeah, let me just add to that,
Yeah.
Anna, because something I didn't mention regarding sending cases to the tribunal, while the Integrity Commissioner has all the powers of the Inquiries Act to go to investigate wrongdoing, he can subpoena evidence, he can demand testimony, he can go onto premises and seize documents. He has all that power. When it comes to reprisals, he doesn't have any power. All he can do is go and ask the people, have you done something naughty? Were you taking reprisals against this person? Oh, of course not. They were just a bad employee. That's about all that they can do. The people don't even have to talk to him. And yet he has acted as a gatekeeper and sent nearly everybody off to their fate.
So Ian,
Yes.
is Canada the worst?
I'm sorry?
Oh, it's for Ian. I was going to ask him, is Canada the worst?
Well, I studied while I was doing a PhD. I compared Australia, Canada, and the UK. And of those three, yes, it's the worst. In terms of performance, it's hard to tell between Canada and Australia because they're also not very. Everywhere you go, people aren't happy with their law. Everywhere you go, there's something that's not quite right. But yes, if you look at the broader picture, which GAP has done, the Government Accountability Project has done, we are at the bottom of the pile. In fact, if I only disagree with one thing in their report, and that is that they rated us too high on the one point that they gave us. They gave us a point for reviewing the law. When we did it once, we did it 10 years late, and well, now they say they're doing it again, but we're not very confident that the process is actually going to get to the root of the thing, because the root of the problems in the law, because they haven't invited any advocates, they haven't invited any actual whistleblowers with lived experience.
Oh, wow.
Yeah, there's nobody on that panel who has actually been through the whole process. There's one or two people who have a lot of experience with whistleblowers, which is encouraging. But in general, the whole tone of the thing is very much, again, favoring the government view. If I were to compare, Canada to countries that are considered best practice, such as Ireland or Serbia, we don't even come close. I would argue that, as Anna was saying, the fundamental problem is that the mindset behind the drafting of these laws was very much to protect the organization, to streamline whistleblower complaints into an established process that can be controlled by the government. Whistleblowing protection is very much the secondary concern, and it only really comes via confidentiality requirements and redress, which can come many, many years after the fact, during which time the whistleblower is suffering the reprisals, may be unemployed, watching their life savings dry up as they employ lawyers on their own. Mm-hmm. But I've actually missed the worst aspect of our particular law, and that is that it only covers the public sector. Mm-hmm. It doesn't cover the private sector at all. So all the things that we've been talking about thus far have been about public sector whistleblowers and whistleblowing. If you are in the private sector in Canada, you have essentially no protections at all. The only tiny sector where you'll find some protection is if you're making a disclosure to the Ontario Securities Commission where there's been some sort of fraud, and then they have a reward scheme there that attempts to parallel what the United States has done. But the results haven't been exactly spectacular, partly because our markets aren't so big. But yes, other than that.
Yeah, I just want to jump in and amplify what Ian just said. He mentioned about getting 1 point. This study was carried out by the Government Accountability Project, which is the leading NGO on the planet in this field. And the International Bar Association in the UK, two very well qualified organizations. They looked at about, I think the number is about 50 countries that actually have national whistleblowing laws. They use a 20-point scale. They have 20 criteria that they look at. And it's a very crude system. You get a point for each criteria that you appear to meet. We got 1 point, and as Ian said, we didn't deserve it. Because the review that we did, the government completely ignored the results. They did nothing with the results of the review, and a unanimous committee report.
And a committee that wasn't that interested at the beginning. David brought, so many experts from around the world and within Canada to that committee. And what I find so interesting is when you start off, especially with they were almost anti having the review. They didn't really want it. But by the end, they were so interested and they were so engaged. And it was a very serious review calling for an overhaul. And it was completely ignored.
They called for sweeping recommendations to the law. And so just to finish my point here, so the government did nothing with that review, which, so why did we get a point? But the 20-point scale, the countries that we would typically compare ourselves are in the 14 to 15 point range. That's a decent score. The entire European community is driving towards strong whistleblowing laws that are going to score up there in that range when they're implemented. We are at the back of the bus. We are the laughing stock of the whistleblowing world. And people who talk to us just scratch their heads and say, what is going on? We thought Canada was a well-governed, progressive-minded country. What on earth is going on there?
So I would just want to go back to something that Anna said, because I thought it was really interesting that at first they weren't interested and then they became interested. And so I was wondering what changed. And then have you got any thoughts about why in the end nothing happened?
So what changes is if you actually get people in a room like we're doing now, it is a fascinating topic. What happens with those, and it's continuing to happen with the judges in Serbia, and the prosecutors now want to be trained. Of course, they didn't want to be trained at first. You ask them, do we want to be trained in whistleblowing? Absolutely not. But if you create a little bit of competition and the judges say this is important, they now want the training too. But what you get is people getting it. Actually understanding what this is about the public interest. So when we, and I was one of them, I do credit David for really working hard to get the right people in the room to talk about these issues, experts from around the world and experts within Canada, because it's not as if there aren't experts. I mean, there are whistleblowers who become experts by mistake, and through, sort of a birth by fire, and it's not fair. I mean, I've been working in this field for a long time. I do not want to live in a world where we rely on whistleblowers. That is insane. I don't want to go into a hospital going, my kid will be fine, because I know there'll be somebody who will take the risk to speak up. I want those systems to work. I want the whistleblowers to be backup. I want them to be heeded. If they're listened to early, we prevent harm. It sort of doesn't make sense. But if it's set up as a fight between an employer and employer, an employee and an employer, and that's how the employer can put it, then yes, it won't go very far, and people aren't that interested in the sort of there. Now there's a lot of interest because I think lots of people are getting it, but that doesn't mean the government has changed its view. It's like, turning the Titanic, unless we get the kind of engagement, unless we start talking about it more in this much more interesting way, unless the media starts to see this as like, hold on a second, it can be the fight, it can be the David and Goliath, or, when we first started when I was working in the UK in 2000s, they'd say, did they lose their job? Oh, well, if they didn't lose their job, it's not a whistleblower story. It's like, so in order to be a whistleblower, you actually have to suffer. And we used to say things like, well, Christianity wouldn't have got very far if you had to be martyred in order to be a Christian. Why don't we learn from the one and stop repeating it. And I think this is the idea that it's something that Canadians should be outraged about. I think that's where we've got to hit, not because we want people to be outraged, because I think Canadians would get this. You know, they would say, of course, if you're working in a lab and you're running a clinical trial and you can see that it's not going to have, they're wrong trials and those drugs are going to be based on things that won't work. Canadians would go, what? Of course that person should be able to speak up. You know, the fact that they're junior or new shouldn't matter. It is something that I think Canadians would agree with, and that you want the law to back them up. It's not about having a God almighty fight. It doesn't have to be.
Right. So I want to go back to Ian for a second, because there's something you said earlier, Ian, and I've actually got 2 questions for you, and I'm going to try to maybe throw them in together. You said that the private sector is not protected in Canada. So my first question is the private sector protected in other countries? And I was also just curious if you'd speak about what happens at the provincial level.
So yes, the answer is yes. In other countries, the private sector is also covered. The Irish law covers the private sector as well. They have special provisions for the public sector. The same with the UK law, as Anna was saying, it applies to everybody. And in the United States, they have laws both for public and private sector, so they try to cover it. And most states have, I haven't studied the states, but most states have some form of whistleblowing protection nowadays as well. So it's not uncommon, although it's frequently depicted by Canadian officials as being unworkable, you know, because there would just be too many complaints to handle, I guess. Now at the provincial level,
I need it.
yes, exactly, right. You know, it's a system. Further to Anna's point, a system that is used. We don't want people to have to suffer as whistleblowers. But if a system is safe enough, it stops even being thought of as whistleblowing. It just becomes speaking up. And many organizations prefer that term, speak up culture, one in which people can just raise a concern. You know, hey, have you thought about X? Let's fix X, and nothing happens. But to answer your question about the provincial level. What we've seen here in Canada is that the federal government was the first to pass a law, and Ontario drafted one in the 90s, but then dropped it, didn't follow through. So all the other provinces essentially copied what the federal government did, but in general, I'm not saying all of them did. Some are better than others. I've looked at BC; it's a bit better than most, but in general, they've actually had laws that are more narrow, have more restrictions on how a whistleblower can speak up, to whom they can make their disclosure. In Ontario, for example, you can make a disclosure to, one of the people you can make a disclosure to is the ethics official in a department. And for the longest time, I thought that was an integrity person in the department. It turns out it's the deputy minister. Oh. The deputy minister is automatically implicated in any wrongdoing in the department, either directly or because they didn't detect it earlier. So it might go well, but it might not. Other provinces don't include things like codes of conduct or codes of ethics. The federal regime at least allows people to make a disclosure about violation of the code of ethics. I don't know how many of those have been reported versus substantiated, although I have seen a number of them come up. They seem to favor these because they usually involve individual misconduct rather than systemic. So in general, the provinces have laws that are weaker than at the federal level. Some of them aren't used at all. I don't think the New Brunswick regime has ever been used. Nova Scotia's hasn't had any disclosures for the past few years, whether that's due to COVID or whether people have completely lost faith in the system. We don't know. They don't collect enough data on observed wrongdoing to make any kind of an assessment of what the cause is. In general, it's just poor across the country.
So I want to just throw a question out there for everybody, and just jump in and take your turn. But we've heard a little bit how people have tried to fix this, and I guess I'm just wondering, you know, is anybody working on it now, or are there any next steps? What can be done?
Well, that's this is the $60,000 question. How do we fix this? because, you know, I've been working in this field for 17 years now, and I see lots of progress in terms of people coming on board. We've got wonderful talent around the world, people like Ian coming, surviving his horrible experience and putting his life back together and becoming an invaluable asset in our, and there's lots of people, we have a lot of people like that, people like Anna, who's doing fantastic work at an international level. We have all the resources and the competence, and we have our own criteria that we wrote for Canada. We had that moonshot where we got a parliamentary committee to unanimously endorse sweeping changes that have been completely ignored. So it seems like we've applied everything short of a nuclear weapon without having any impact on this wall of intransigence and you know, an entrenched view that nothing is going to happen. And you know, if you go back to that review in 2017, which was 5 years late, members of that committee told us they suspected the reason they'd been asked to conduct the review was to distract them from another scandal that they were digging into that would implicate the government, to do with military procurement. So I think the government threw this to them as a bone to distract them, thinking it was a safe file. And of course, it blew up because they actually dug in and got to understand what was going on and wrote a terrific report. So that's the kind of intransigence that we're faced with. And when in our struggle to keep our spirits up and find some hope here, we talk to people like Anna and we look at other countries. And what we see is that nothing happens and nothing happens while you're laying the groundwork and preparing preparing for what may happen. And at some point, the wall cracks. And then it's like the Berlin Wall, the whole thing just crumbles. And if you've done your homework right and put the right things in place, then things can change dramatically very quickly. At the moment, I don't see the tiniest crack in the wall that we're facing, but I believe that eventually that'll happen. I don't know exactly how.
I think I'm going to just remind people about the Q&A button down at the bottom of the screen. We're going to go to questions in a second, but you gave Anna a nice segue there about maybe how this has gotten resolved in other countries. Do you have thoughts, Anna?
Yeah, I do. I think part of it is that, you know, people don't give up. And guess what? Whistleblowers keep coming and tragedies and scandals keep happening. And the connection needs to be made in people's minds. And I think I've only sort of like reviewed the questions in passing, but I saw somebody say, I think it's John Delzeal, saying that, you know, he believes that the facts of the incidents that he was speaking up about in transportation safety, if they had been dealt with, then Lac-Mégantic, the disaster there, might not have taken place. And one of the things that I've seen quite effectively done in different countries, and one of the ways in which the Public Interest Disclosure Act was put on the books, again, there's serendipity involved with elections and who's coming and who picks it up and all that kind of thing that happened in the late 90s in the UK. But the organization that I worked for did reviews and looked at inquiries, and in the Canadian system and the UK system, we have, you know, this wonderful royal commissions and inquiries that we have, and they would look at what stopped people from speaking up. And you could see that building. They had the Piper Alpha oil rig explosions, and I know we've had issues with the oil and transportation and I'm going to call them the tar sands because that's what I think of them as. But you know, things are happening that are causing problems to people's the land and to drinking water and Indigenous rights throughout Canada. There are things that have been happening. We need to start making the connection because it's not as if people aren't speaking up, you know. And that was one of the things that we always talked about. People are talking, and we would tell employers they're talking at work, they're talking down at the pub, or they're telling at home. And when it starts to get serious, those people are saying, either nobody does anything and getting us, you know, why would you stick your head above the parapet? Or family members going, don't you be the one. because, you know, we see this happening. Why are you taking this on? So again, I think we need to just keep pushing. And when we have done that, and especially putting it to politicians as often, it'd be great if media did this a little more often, and that they were asked. You know, it'd be great if Trudeau was asked, did you know Canada had the worst whistleblower protection law in the world? You know, that just getting people to say that and putting it on record, it does start to, there is an answer. And when they suddenly want an answer, they will look to all of these experts, and they will look to David and Ian and the Centre for Free Expression and other organizations in Canada who are ready and who have some answers. But unless they feel that connection and understand that connection, then it takes longer. And that's what happened with the UK law. When Tony Blair first came along, it was a private members bill, and I know there's been some questions about that. And it got support, so it kind of went around the government program. And those are rare to pass, but they did pass. And in the EU, 3 years before we had the law that was adopted, commissioners were standing up and saying, absolutely not. We don't even have the legal authority to do an EU directive. They found it when they had journalists being murdered, sources being undone, and some of the big scandals like LuxLeaks in the European. LuxLeaks was a huge scandal with one of the major accounting firms in Luxembourg, where and it started to blow this idea that accounting firms were negotiating for private companies to like put their taxes through Luxembourg, even though the profits were made elsewhere, and it caused a big scandal. And that all pushed the commission, because the answer was to have whistleblower protection. And then we were ready. So I think, you know, Canada's not without scandals. I don't want people to have to live through this, but it does seem like, you know, it'll take one more for somebody to go, this could be an answer. And that's all it is part of the solution. But it's an important piece. And I just think it shouldn't be ignored anymore in Canada. It's not okay for the status quo to carry on.
Thank you, Anna. And Ian, solutions, thoughts before I go to questions?
Well, I was just going to first respond to John Dalziel's comment about the Lac Mégantic thing. I suddenly found somebody I have a direct connection to here, because the actors in the Lac Mégantic episode were exactly the same people. In my own case, it involved an assistant deputy minister who was the DG at the grievance hearing I was at. It involved my director, who became the director for the transportation of dangerous goods. It's all the same people. So it's evidence that if you don't have a system that works, there are consequences. As to how to fix this particular problem, I think we do probably, as Anna said, need some sort of a tipping point, and there'll have to be some significant reforms to both the law and perhaps education efforts within the senior public service. Because one of the things I have found is there are a lot of misconceptions about what whistleblowing is. Most of them perceive it as something that only happens external to their departments. They don't understand that people have been trying probably for months, maybe years, to raise the issues internally. There's also some resentment towards even the Integrity Commissioner's office. They view the offices as meddlers looking to stir up trouble. I've heard stories about interference with Integrity Commission offices. There also need to be some standards for these regimes, where the investigations have to meet standards. So it's at all different levels. It's almost too broad a question to answer, but there does have to be a genuine commitment to reform.
So I'll go to questions now, and I think in some measure you guys have answered this one, but maybe with some examples of how it works. The question is, do any regulated professions have their own whistleblower protections or policies?
Yes and no, from my experience. I mean, I do think that some of the regulated professions, like lawyers, now that's a good one, have made slow advances on, but I think even training lawyers on how, say, these laws work, and that they, we spent a lot of time in the UK kind of shouting at our associations for for only representing, the big players, who could pay them, not doing any cases that might not be so lucrative, and also not treating it as an employer issue, and kind of jumping in, or not seeing the whistleblowing issue. And that's a big one. For themselves to raise issues, I think that's come up more in accounting, I think, than in any other field. And I think that's a really interesting one, that forensic auditors, for instance, have been very good on this, because they're called in to do the audits after the fact, or to do serious investigations. And so I would say police and auditors often get whistleblowing because they understand that the people are giving them valuable information. They don't expect them to prove the wrongdoing. That's the other thing that happens. People are saying, well, if you think this is the harm, you have to prove it. It's like, what do you mean? If you're a witness to a crime, you usually don't have to prove the crime to offer information. So auditors have been good, accountants are good, and the professional bodies have started putting codes of conduct, have started to try and give, some of them have set up advice and helplines, because for those who are regulated, they themselves could lose their their livelihood as lawyers or accountants if those bodies remove their certificate. So they have two issues, right? An employer and their professional bodies. So nurses have done some work, and I'm speaking more from past experience in the UK, but I know that some of this has been happening in Canada, and I know there's interest internationally, particularly around the accounting field with corruption issues, because it's been shown in study after study that it's when people tell you where to look that the most frauds are picked up. It's not through audits. Audits won't pick up where the real bodies are being hidden. And we've seen big scandals in the US in particular over the years with WorldCom and Ron, where stuff was hidden until it all blew up and lots of people lost their jobs and a lot of harm was done.
Thank you. Sorry, did you want to jump in? Yeah, I'll go to it. Yeah.
Let me just I'm glad that Anna's aware of some movement in Canada. But my general impression, without having a lot of detailed knowledge of the various professions, is that it is a problem generally, because what the professions tend to do is lay codes of conduct on their members, which oblige them to speak up when there's a problem. If I'm an engineer and I see faults in the construction, the bridge is going to fall down, or the airplane isn't going to take off, I am obligated by my code of conduct, apart from anything else, to speak up about that. But then these professional bodies tend to be missing in action when the person suffers the consequences of that. So to me, that's the pattern that is the status quo. And I'm glad to hear that there are some professional bodies that are moving away from that.
And part of this may be due to the fact that professional organizations often don't have the tools to necessarily protect the members who are whistleblowers. Yeah. That has to fall often on government or some agency that'll do this. And again, this is kind of returning to your question about how to improve things. Protecting the whistleblower is perhaps the most important part of any whistleblowing legislation. Unfortunately, when they're drafted, this is not what's first in the mind of the people who are drafting them typically. If you protect the whistleblower, you keep the issue alive. And if you keep the issue alive, you're protecting the public interest. That's the key element here. And so what can a professional association often do? And I got the impression from my union, in particular, when I was going through my case, is that they kind of threw their hands up and said, well, what do you expect us to do? The government has all the power here. There's nothing we can do.
Thank you. I was thinking of that, and I was thinking particularly about that idea of having a professional obligation to speak up and then not having the protection when you get there. Huge problem. I'm going to go to this next question. This is a little technical, but I'm sure you guys can handle it. Is there any room for judiciously reviewing the prosecutorial discretion of the apparatus that purports to protect whistleblowers? Unlike other types of law enforcement, where prosecutorial discretion is generally considered to not be revisable by the courts, it seems in this case to entirely thwart the stated intention of Parliament?
Again, I haven't worked in Canada directly in the legal field for a long time, but in the UK, there is a public interest test to prosecute. So I'm not sure how reviewable it is, but certainly I know that the head of the prosecution service can often find themselves having to respond to that, and because they have to publish, what the cases that I think they have to do a lot around which cases they take and because there is an actual public interest test of taking a prosecution. I'm not sure whether or not that's judicially reviewable by others. So I think that's a tough one. I mean, it's an interesting idea. But prosecutors, discretion. I do know, say, in the European side, prosecutors are the sort of one of the last bastions really to start to be questioned. Judges, and the appointment of judges and how court decisions, because those are public forums, they get a lot more scrutiny in terms of accountability and independence than the prosecutorial authorities do. And so I think that's an area that we need to explore further.
Yeah, David, Ian, do you want to add anything?
I'm not a lawyer, but I do know there's one of the core cases behind judicial review is the Vavilov case. And this case basically sets the standard at which the courts can review an administrative decision. And they've basically drawn a fairly broad picture of, the process has to be competent. There have been reviews of a number of cases that have gone through the Integrity Office at the federal level and been sent back with the court saying, listen, you have to allow this person to apply to the tribunal, for example. Your job is not to stop compliance. Your job is just to make sure that there's a case to make at the tribunal. But that's about the extent of it. As to prosecutorial, I'm not quite sure how that would look.
So Ange may have some more. Ange may have some more. Ange is surveying the questions and picking out what we may be being asked to respond to. One comment I'd throw in here is that when we get deep into discussions about the intricacies of the law, everyone involved in this is human. And it really doesn't matter what's written in the law if you have people who are just not going to, who see whistleblowers as troublemakers. It doesn't matter what's in the law. And we've seen cases of that where we get absolutely absurd decisions, which often become precedents because, the person in the chair has a certain strong view. And you'll see this in every branch of law. If you think of women's rights, changing the law is just part of it.
Okay, and Ange, have you got more questions for us?
Yeah. The next question is for David. Why has the Integrity Commissioner forwarded almost no cases to the tribunal? Has it been the same commissioner for the entire time?
No, the simple reason that I haven't talked about the Integrity Commissioner's failure to investigate wrongdoing, which is the other part, the main part of his job. But the problem is that we have, since this law was passed, the Integrity Commissioners appointed have been career bureaucrats who are trained and socialized and indoctrinated that their job is to protect the system, not embarrass the minister or the high-ups. And that's exactly what they've done. And so the first commissioner, Madame Christiane Ouimet, she achieved a perfect score. She found 0 cases of wrongdoing and 0 cases of reprisal in 3 years. And she was eventually retired in disgrace because the Auditor General was called in and reviewing what she was doing. And the Auditor General reported that she was basically doing a lot of the things that she was employed to drive out of the public service, like taking reprisals against her own employees. So that was a disaster. But there's 2 subsequent Integrity Commissioners are cut from the same cloth. and make very similar decisions. And in the reviews that Ian is talking about, not the specific case that Ian mentioned, when they're told they made a mistake, they would double down and redouble their efforts to do what they were already doing in defiance of what the courts are saying. So these are people that are very determined not to rock the boat, because it's just not their nature. And I'll also mention that we had a PSIO, a public sector integrity officer, prior to this law, who was much more effective, Dr. Edward Kaiserlink. He did a splendid job. He was there for 3 or 4 years and did an excellent job. He advised the Public Service Commission, the PCO. He advised them to ensure that any future integrity commissioner would be drawn from outside the public service for this specific reason. PCO said, "Oh yeah, we absolutely agree. That's what we're going to do." And then they did the exact opposite. He was told that they would look at people outside the public service. He recommended a couple of people who he thought were eminently qualified. Their applications were not even acknowledged, and so. What we've got is a strategic decision made in the heart of government to employ safe hands. We put this power in the hands of people who know not to cause grief in government, to the grief and embarrassment to the government. More
And
questions?
and sure.
Yeah, you ready for a question? Yes, please
Yeah.
ask me when you're ready for the next one.
Yeah.
The next question is from Stanley. Stanley asks, what are the panelists' thoughts on how to navigate through whistleblowing as the society becomes less democratic?
I can jump in just because it's been an issue across the world. And obviously when I speak, it's not because I'm a world expert, because I work with people who let me know what's going on around the world. And certainly when for countries who've always had or have been fighting democratic deficits for many, many years, the concerns are not just employment protection, but other forms of harassment and threat. And we're starting to see that generally with people getting threats, physical threats, whether they're whistleblowers or journalists or female politicians, where that kind of is seeping in. And it doesn't help any of us, stand up and call power to account and on all of these areas. But I think one of the things that has happened within the civil society organizations who say work on anti-corruption or human rights or transparency issues. I would have said 20, 30 years ago, people were quite precious about their spaces. They were the experts in their fields. The pot of funding was probably, they were all a bit in competition. And in the last 10 years, it's been like, no, we're all in this together. We all have this common goal to be able to call power to account, to review what people are doing, to do our independent investigations, and to let the public know. And it leads back to what Ian was saying. It is very much freedom of expression includes, and is in the European Court of Human Rights cases, includes the public's right to know. And so one of the things that whistleblowing is about is very much ensuring, through the ability to speak up, that the public gets the information they need to make decisions, like we needed during COVID, about what we did, washing our hands, having the right equipment. As that was learned, we needed to know, and we needed to know when that equipment wasn't working. So I think the thing about this is that what happens is people come together, and that really is part of making up for a democratic deficit. In some ways, when everything's working, people just get on with their individual lives. But when it's not, we work together. And so it's like there's almost an effect that there's a democratization of collaboration and working to make this work. And that's what I've been seeing across Europe and across Africa and Latin America as well. So I do think it's time for those of us who maybe haven't been sort of seen some of the shocks as close up. And, you know, in Europe, all these borders and things are happening. People are watching other countries, and we've got the US, which may have been a big shock in the last few years to many of us. But it is really important that we see all of us as part of this, calling power, you know, holding the decision makers to account, which doesn't mean blaming them. It's saying, do explain to us how you made that decision and whether it was the right one. And sometimes we might not agree.
And it's not just, it's here in Canada too. Dave, Ian, do you have thoughts?
I would say that one of the problems with the eroding democracy is that dissent becomes harder and harder, and whistleblowers are an easy target because they're already vulnerable. It becomes progressively harder, and that's what makes protecting whistleblowers all that much more important, because they are, in a sense, one of the bastions of any democratic process.
Yeah, I do see in one of the things that whistleblowing achieves, it does protect the integrity of our institutions. And that's what's at stake here, you know, when our institutions just stop functioning. And, you know, if you look at what social media has done, then it is driving us apart and driving us into polarized echo chambers. And what I see a lot of is people presenting themselves as whistleblowers who are actually just conspiracy theorists and, you know, extremists, that society is trying to control how much of a voice, how much of a megaphone they get. But yeah, so it works both ways. Whistleblowing becomes harder as democracy goes into decline, and without whistleblowing, democracy is less protected.
And I'll just say, as a journalist, I feel the polarization every time I write something.
Yeah, absolutely. Yeah. Ange, have you got more questions for us?
Yeah, there was a question actually from Sandy that was earlier when, Ian, I believe you were talking about legislation, and Sandy said, so Serbia has a better whistleblower protection program than Canada. Could you all comment on that?
I think Anna is probably in a better position to answer that because she's more familiar with it. I just know of the gap assessment.
I would say yes, because it has worked, but it doesn't mean that there aren't problems in Serbia or that there aren't other serious issues around corruption and political corruption. But at the local level, and one of the main organizations working with whistleblowers day in and day out, and doing sort of the more the local level of what's happening in Serbia and from with corruption in local authority procurement, is Pištaljka, which means the whistle in Serbian. And again, I think it's because the civil society has been closely involved, not only in helping finalize the detail of the law, but and this, as I said, civil society in this case involves, you know, the professions as well, and people who've gone through whistleblowing, and some international advisors as well. But it was a very much a born and bred law in Serbia. They took it on the road for a year and did consultations around the country. So at a certain level, that is working well. It doesn't mean that it doesn't need the civil society organizations all the time working on it, like all the time. This isn't something, this is like a citizen's charter, really. It isn't, the powers that be are always going to quietly go, well, you know, everything's going well. Do we need it? Slowly chinking away at it because it's a default mechanism. This isn't comfortable. And I think I wanted to just go, you know, you can look at two things, right? I run an organization. There's people in this room that work in organizations. We want to know what's going on. We do want to control what's happening, or we'd like to think we'd be able to. Whistleblowing is uncomfortable. Whistleblowing is when information goes sideways, and you can't say when a whistleblower is going to come up. But what we would say to organizations is they're already there, and they probably already told you. You weren't listening. So it is the difference between this kind of information control system or an actual accountability mechanism. And you can see the default in Canada has been information control system. And then the idea, as Ian said, that people think whistleblowing is only when people go outside. It is absolutely rare that people go there first. It's a nuclear option. It's not a comfortable option. Most of you would say, I would not think of going to Karen first before I talk to my manager or try the senior person. You know, everybody thinks they're going to address it internally. So we need these backups. We need there to be alternatives. It's like a little river going around a boulder. You know, you want the water to keep flowing. It's about institutional, it's the free flow of information for institutional accountability. That's what whistleblowing is. If it has to go out to get that institutional accountability, then so be it. I'm all for it.
Thanks. Ange, do you have another question?
Yeah, I do. The next question, an attendee says, thank you for your presentations. This question is for anyone. I have sent this anonymously due to potential further reprisals. Can someone speak to some of the issues related to whistleblowing related to Indigenous cultural fraud? For instance, Brianna Lavalley Heckert raised concerns about a coworker's claim to indigeneity and ended up resigning and being accused of having mental health issues, not unlike the repercussions you have discussed. In academia, we have seen people who have blown the whistle on fraudulent identity claims and were accused of jealousy, and the institutions only acted once the fraud was undisputably profiled in mainstream media. However, the initial whistleblowers are left ghosted, resigning, retiring early, gaslit, and facing formal complaints of harassment and human rights violations. Is there any hope? Could class action lawsuits be a possibility?
Depends very much on the provincial regime in which the act takes place and whether the act or the person is covered by a whistleblowing law. Most provinces don't include, for example, academia in their whistleblowing law, so they wouldn't be protected, unfortunately.
Yeah, Ian, why is that?
Well, they've tried to just focus on the public sector because that's the area that most affects them, I think. It's gradually expanding in some jurisdictions, you know, to the healthcare sector, for example, in Saskatchewan, and I believe BC is gradually doing the same sort of thing, and in academia. But it's often also cases like this might take place before that coverage occurred, or there might be interpreted immediately as not being that a whistleblowing case. I'd have to know more about the specific case to answer why it and where it took place to answer why it wasn't handled. But in general, the people who are covered by the laws is just too narrow to catch most of these cases.
Thank you so much. Ange, if you got another question for us.
Yeah, the next question. This session title refers to a war on whistleblowers. Is the situation for government whistleblowers in Canada you have described as ineptitude and lack of understanding, or is it more sinister?
Oh.
Well, I think we've all got views on this. I'll kick this off. I worked as a consultant. I ran my own management consulting practice for many years before I got involved in this field. And one of the things that was striking to me was how often you found the senior leaders were in a little bubble, quite disconnected from reality. They didn't know, we would find out within hours of coming on site information that they had no knowledge of from people that were working in offices a few doors away, because the hierarchy prevented them from getting information. They didn't know what was going on in the front line. Information being sent to them was progressively cleaned up as it went up the line, so that it was all sanitized. And the biggest worry was they had no understanding that this was going on. They really believed that people were telling them freely everything and were not scared to say anything to them, when the exact opposite was true. Now, not every organization is like that, and healthy organizations are quite the opposite. But I find that was quite a common phenomenon. And I know from Ian's many interviews that he's done with senior people, a big part of it comes down to just simply not having a completely different view of the world, and seeing these persistent whistleblowers as just troublemakers, you know, just out of the way and let us run the business.
That's a good segue to Ian. Do you want to comment on that, Ian?
Yeah, to add to that, they have blind spots. You know,
I spoke to the New South Wales Integrity Commissioner there. They have a corruption commission there, and he was very frank about the limitations of their ability to enforce the rules. Part of it is that when they draft these laws, I think there's an assumption that everybody is going to be on their best behavior as the process moves forward. That these laws are built for best case scenarios. They're not built for worst case scenarios. Part of that is because the politicians are usually the one who kick it off because they see a benefit from implementing the law. They can then say they've dealt with a specific problem and that in future it won't happen again because people will be able to report safely. The administrators are not quite as keen about it because they see it as just another obligation. They have misconceptions about what's going to happen with the disclosures. They don't want issues to suddenly bubble up. One of the concerns was that the system would be completely swamped with complaints if they made it too easy. I've heard this time and again, which is bogus. People don't risk their careers making up allegations or just bringing trivial issues forward. They bring them forward if they're important. So a combination of naivete on the part of politicians whose attention just quickly shifts to the next crisis, perhaps a bit of cynicism by some of the actors, and just not understanding what the phenomenon is really.
I would add that probably sometimes outright hostility to giving power to people, giving it away. And then I would say that another element is that the reprisal aspect of it can be deeply personalized. And it is the point where somebody feels like they have been wrong-footed. They feel like they've been publicly embarrassed. So we've seen cases where the issue will be dealt with, but the whistleblower will be so they've dealt with the issue, but they will still slaughter the whistleblower because that person isn't a team player, and that's their view. So Jess Staley, who's now in total trouble, but he was an American who was in charge of Barclays Bank in the UK. They had a really serious whistleblowing program, and some of the banks have actually, to the point that they've got ex-police officers running the whistleblower program. They will not reveal the identities of whistleblowers to the senior level. Well, there was a case that was, that worked fine so long as it wasn't a case that raised issues at the senior level about decisions made by the senior people, and it was about some hiring practices, and the basic issue was dealt with. Nobody got, it wasn't considered, I think, even grounded in the way that that was high enough. So it was dealt with properly. And then Jess Staley wanted to know who the hell that was, and undermined the whole Barclays Bank system, and got rid of the head of the whistleblower program, and was personally fined by the US authorities and the Financial Conduct Authority because they don't like it. That's when it gets personal. It's the idea of having a good system where all those things that you all do gets dealt with fine, but come near me. And that happens at big NGOs as well. I mean, in Oxfam and some of the scandals they've had in Haiti. So every organization has this kind of default that can work against it, and naivete. And I would say most people aren't out to harm whistleblowers or would even think of it that way. By the time they see the whistleblower, they've also been presented a view and they see it through that view. But when it comes to the point where the reprisals start to happen, they want people to go away, then I think there is malice there.
And to add to that, I spoke to an Australian whistleblower, and he had a rather colorful story about how complete bystanders, people who had nothing to do with the disclosure or the wrongdoing, would actively volunteer to participate in the reprisal. So there is this tiny set of people, a very small set of people, who are willing to be collaborators to advance their careers by protecting the wrongdoers in some way, shape, or form. Nobody's ever really studied this, but it would be an interesting question to see how many whistleblower cases involve collaborators helping the wrongdoers.
But they get oxygen by those who just don't want it to do it well, right? So I think we have to go back to, we can focus on the malicious sort of against whistleblowers, and they can focus on The occasional person who gets it really wrong and is out to get the organization, very, very rare, but they build the whole system to stop those people so they don't hear from anybody. So I just think we want to say that well, I would like to say, and I'm sure that my colleagues would agree, that we want the default to be to give more air to the whistleblower, to give more air to the issue, and for it to be seen as a collective responsibility. Because the more we don't do that, then we give the tools for those who want to go after these people and show their true colors. And we just, they're still a minority, but why would we give them that?
Yeah, something I often say. Something I often say is that, what we really want is due process. When someone raises an issue, let's treat it seriously and give it due process. And that protects everyone, because it protects anyone that's wrongly accused. It protects the whistleblower. It protects the public interest. And that's what's so hard to accomplish when their emotions are high. People, if you talk to people like our colleague Sandy Birch, who does a lot of forensic investigation, they talk to people in the organization. All they want to talk about is speculating about who is a whistleblower, who is it, and let's talk about that and make guesses and whatnot. There, as to what the wrongdoing is, that's much less interesting.
Let's see if we can squeeze in a few more questions. Ange?
Yeah, the next question actually came from a couple people. Can you point to Canadian organizations that you think are doing a good job of protecting whistleblowers?
I believe from my colleagues who work more in the private sector that there are some private sector organizations, large corporations, who have fairly good systems in place. And, this is secondhand. It's from someone whose judgment I trust. I don't know how extensive that is. From where I sit, I don't see anything, but, that's partly a function of focus on government. And at the provincial and the federal level.
Part of the problem is that if the system,
Be really quick because I want to get a couple more questions in if we can. Go ahead, Ian.
I was just going to say, part of the problem is if a system's working well, you never hear about it. That's the problem.
Okay, Ange, a couple more if we've got time.
Yeah, the next question is from Dale. Dale says, asks, I would like each of the panelists to share their answer to this question. If you could make 4 changes to Canada's Whistleblower Protection Act, what 4 would be at the top of your list?
Great question.
I think we'd all agree on reverse burden of proof.
Yeah.
Yep.
Direct access to the tribunal without that gatekeeper
independent
function.
oversight. Yeah.
A duty to protect whistleblowers by our organizations, and interim relief.
Interim relief is really important. We're going over the 4 here, but I would like to add appointment of an integrity commissioner who is outside the bureaucracy, who can be truly independent.
Top 5.
Fabulous. Thank you. Ange, have you got another question for us?
Yeah, what media outlets in Canada or in the world are good at covering whistleblowing topics well?
Okay. In Europe, we're seeing a lot more maturity in the field generally. And a number of journalist organizations. So what I've also seen is not that journalists have gotten, and Karen, I'm very critical of lawyers and I'm a lawyer, but I know from my friends, getting a story and it being your story can be part of a journalist's way of operating. And there's a lot of misunderstanding between whistleblowers and journalists. I think a lot of expectations on a whistleblower's point of view, and that has to be managed really well by the journalist and also by those advising whistleblowers about the role of journalism, and they have to do their own due diligence. But I would say what's been happening is this younger generation, partly because they're getting data leaks of such vast amounts that they're sharing stories, and they also have sources coming to them and they really want to protect them. And what I found in working with journalists and with whistleblowers is they may come to these organizations, journalist organizations and advice organizations, and want to stay anonymous until they feel that they're listened to and properly believed. And so I know that some of these journalists now know who those sources were, but would never reveal it, and have learned a lot about about what it means to be a whistleblower, have really been interested themselves about what makes somebody come to them. And there's sort of a consortium of journalists who are working together. And often now when they get stories that are cross-border, because that's what whistleblowers are showing us, huge cross-border cases, because that's where power has been going for the last number of years. And I know some of the Canadian stories have been about Canadian mining companies and their activities elsewhere. So even if Canadians don't see it in their country, they should be very concerned about how Canadian companies are operating in the world, because they're not always behaving very well at all. So you can see that they're working together. So I'd say there's not one media organization that just is, you know, exemplar, but what I would say is certainly in the cross-border cases and big cases, they're working much better, and they're very clear about thanking the whistleblower, but not focusing wholly on the whistleblower. So they give credit, but they focus on the wrongdoing. Whereas before it was like, let's focus, that's so interesting. And the wrongdoing would just be so secondary to the story, because often it can be a little bit later too. So they don't say what the public interest is about. So I'd say it's advancing, but I still think there's a lot of work that journalists could do with each other, and that whistleblower organizations could do with journalists, just to talk about that space and that interaction, because they do have different roles, and journalists need to do their work independently, but that could be handled a lot better, I think.
We're going to have to wrap up, but Dave, Ian, do you want to offer a final thought or jump in on that question just before we go?
I would just add that it sometimes depends on the individual journalist. Some of them are known to be more familiar with the phenomenon and more friendly to it than others. And a friend of mine once said that you need to be a good investigative journalist to get into some of these cases. Unfortunately, being a good investigative journalist isn't always consistent with being a good employee, because that's what he told me. He's a journalist, so.
Dave?
Yeah, I mean, I see the whole field of investigative journalism being kind of re-engineered in a way through technology. There's huge data dumps coming out, and journalists collaborating internationally using really sophisticated tools to dig in and analyze this mountain of information, and then publishing stories in a collaborative way where, you know, they all work to the same deadlines and so on. I think it's phenomenal. And it gives me hope when in the face of everywhere else you look, there seems to be just a collapse of investigative journalism resources because of the collapse of revenue for the print media. And therefore, you know, there's more, the investigative journalists seem to be becoming an endangered species. And I think we've found a partial solution to that.
Well, Ian, David, Anna, thank you so much. I learned so much. It was so great to spend this afternoon with you. Thank you.
Thank you.
I'm going to turn it back to Jim. Jim, jump on.
Well, thank you so much. Before I thank the panel, though, as I mentioned in the introductions, we have as our moderator the editor-in-chief of one of the most interesting media outlets, in my view, in Canada, Canada's National Observer. And I just wondered if you wanted to say anything about that last question, since it was about the media dealing with these issues.
You know, I think one of the things, I guess, that we're trying to, it's always so hard with whistleblowers. And I think there were a few things that came up that really kind of struck me. It's true. You get somebody who comes forward, you have to go through and confirm everything that they say. Sometimes they're coming forward anonymously. They're coming through technology. It's hard to verify. You have to tell them sometimes you can't do the story because you can't verify. But the thing that I'll walk with today that I kind of knew anyway, but I'll think a little bit more about it, was that comment that was made earlier about manipulating media when they push back on whistleblowers, just sometimes how manipulative and untrue it is. And, you know, you get caught as a journalist in between they said, you have to balance when you're doing the story, and you get caught sometimes up in the law. So, you know, strategically, we really have to think about what we're doing there. So that's what I'm kind of taking away as one of the big points on the panel.
Well, I want to thank you, Ian and David and Anna, for a wonderful discussion. I want to thank Karen for a great job at moderating this, as well as being a panelist for the last question. So thank you very much. I want to thank the audience as well for its engagement in this and the many questions. We didn't get to all of them. We apologize for that. A video of today's panel discussion will be posted on the CFE website tomorrow. So if you have any colleagues or friends or other people you think may be interested in the subject and seeing it, please draw their attention to it. Our website is cfe.torontomu.ca. Also, when we post the video, we also post resources for those who are interested in knowing more about the subject, in this case about whistleblower and whistleblower protection. So there'll be some references to articles and or books or YouTube videos or whatever that will be posted along with the video, so that you will have a chance to look into this a bit more. Our next event is going to be next week. It's going to be on Wednesday, January 25th at 4 p.m. And the title of that one is Censorship is No Friend of Social Justice, Protecting Intellectual Freedom in Polarized Times. Our guest is going to be Emily Knox, an American expert on intellectual freedom, in conversation with Tony Samick, one of the leading Canadian experts on intellectual freedom. They're both very engaging on what are the challenges about censorship and how do we protect intellectual freedom in a way that allows people's voices to be heard without censoring them, while at the same time dealing with the very serious issues of concern that lead people to want to censor as a way of dealing with it. So that'll be the subject of next week, Wednesday, January 25th at 4 p.m. For videos of all our past events, they're on our website, cfe.torontomu.ca, as well as a resource material on a variety of issues related to expressive freedom and the public's right to know. Thank you very much for attending today, and I hope to see you again shortly. Bye-bye.